next case, Debbie WILT versus Gary Melvin French. Is Paul Lee here? I tell you what we're going to do. I think we'll postpone your case move it up one notch, and are the attorneys for William J. Rice and Darren Darwith
Mr. Lee's just arrived.
Mr. Lee just arrived.
Paul Lee.
Mr. Lee, you're up. Debbie WILT versus Gary Melvin French. Mr. Lee.
Thank you, Your Honor. I am Paul Lee.
Mr. Lee, excuse me, before, do you want to reserve any time?
Yes, sir, I'd like to reserve 5 minutes rebuttal.
Okay, sir. You may begin, sir.
I'm Paul Lee, representing Debbie WILT, the plaintiff appellant in this action. And may it please the court, this occurrence occurred at its beginning on November 5, 2006, when Debbie WILT, on rural property, had a confrontation with the defendant French, who backed his pickup truck into, over, and upon her person, at which time she was injured, and the evidence shows in the case that she had a herniated disc at L5 and S1. At the time of the incident, there were 4 witnesses, aside from the plaintiff, 3 of which testified that there was a backing of the truck into her person, injuring her. The lone witness who gave evidence that he did not back into her was a gentleman by the name of Bubinus, whose deposition was taken by the defendant, at which time I was present, and chose to ask no questions because of the fact that you're better off if you have critical questions to ask, to wait until trial so as to impeach the witness and draw favor from that examination, which became a calculated error because of the fact, as I will explain, the court ultimately admitted the deposition of Bubinus. And that was actually, in this case, the straw that caused the camel to fall. It's our position in this case that the deposition was inaccurately admitted, and there was no showing in the record that the trial court did not abuse its discretion because it did not follow the procedural rules in admission of deposition. The reason that being that the record shows that the only evidence offered by the defendant in the admission of the deposition of Bubinus was the fact that they had tried to subpoena this witness, Bubinus, and had a subpoena out for him, but they could not serve the subpoena. So the witness had no subpoena for trial, and that was the only way that it could be lawfully admitted, because there was no showing that the witness was more than 100 miles away and did not fulfill any of the other criteria by evidence as to the admissibility of the deposition. Now, we cited a number of cases, and there are a number of cases out there, and none of which gave any light on the subject as to the fact that a court could allow a deposition to be admitted without filling the criteria of the statutes. So the only thing left remaining that could be shown for the admission of this deposition
wasn't the witness, though, that we're talking about on this deposition, Mr. Budness? His location was unknown, and attempts to serve a trial subpoena on him were unsuccessful?
That's correct. According to, now this is the affidavit of the process service.
Why isn't that sufficient to allow the deposition?
Because there's nothing in the statute that provides that. It provides for illness, for incarceration, a number of things, but not just a process server going out and saying, I couldn't serve this subpoena, therefore he's unavailable. If that were the case, in every case...
You said the statute?
Well, the Florida Rules of Civil Procedure, which come down to the rules of evidence.
Okay, so we're talking about the rule. We're talking about Rule 1.330.
Right.
Okay.
And it lists them as follows. The witnesses... should I read those for you?
Well, not necessary. I just don't understand why sub D doesn't apply.
That witness is a greater distance than 100 miles from the place of trial or hearing.
Or because his attendance cannot be procured by subpoena.
Correct. But that doesn't mean, it means you have to serve them by subpoena and then they don't show. And the cases show that.
But could it not also mean that if they've tried to diligently locate that person by subpoena and the process server is unable to locate that person for whatever reason, absence, counsel secreting the witness, would that not mean that the court should allow that deposition in, sir?
No, sir, because it's not listed in the criteria for the admission of deposition. Case of an attorney trying to say that the witness is more than 100 miles away, but the court would not allow that.
So, do I understand your argument to be that because the case law doesn't allow representation of counsel to be sufficient to establish that the witness is more than 100 miles away, then by analogy, the court also cannot allow representation of counsel concerning the inability to serve the guy.
Correct.
To support the admission of the deposition.
That's correct.
Is that your position?
Surely, because in order to comply with the statute, you have to comply with it. It's the red letter of law.
Have you got any case that says that?
Yes, sir, Your Honor. We've cited them, and so has the defense. If that were not the case, in this case, if you were to allow the process server just to come back and say, and we have it happen all the time, we can't locate this witness. If you got a lackadaisical process server and they just want to get the fee and get back, that witness's deposition could be introduced by the court. And the cases are very clear on it.
Well, which case is it that you're talking about being very clear on this?
The case Heverly versus Klan, and we cited that in our brief. 196 Southern 2nd 38. Crow versus Lowe, cited 94-2 Southern 2nd 903.
And what happened in those cases? I don't remember the case by name, but I remember coming across a case that said that representation of counsel was sufficient.
Well, this was a very
for this particular provision. So
there's the case of Hartley versus Klan, a very complex factual situation involving counsel.
That was a 100 miles away case, wasn't it?
Correct. He was willing to sign that because the attorney was willing to sign it.
Right.
Because of the fact that he had discussed with the family and he had some inclination. The guy was in the Army and he was... Right.
So this isn't a case under the section dealing with failure to subpoena. This is a 100 miles away case. And right. Crow v. Lowe is a 100 miles away case too, isn't it?
Let's see. The witness did not respond to a subpoena that was served upon him this was the case they allowed the deposition to go in because the subpoena was served upon him. But in the case of Barr, the subpoena was not served on him.
Right.
Any other questions on that, in that area?
No, sir.
I'd like to speak on the adversarial conduct of the trial court in this case. And I'll take you back to the very beginning of the case in my opening statement when I was referring to the problems a person can have with a permanent injury and that they should be compensated for them. And the defense counsel objected and the court sustained that objection and told the jury to disregard whatever I said. The next thing that occurred in the case was the second day of the case. It was discovered that the husband of a juror was in the audience. And I brought this to the court's attention, and the court made no inquiry of this witness, or this spectator. He did admit he was the husband of the juror. And he also said that he hadn't discussed...
Have you found any case that says that a trial judge must make inquiry if the husband of a juror comes into the courtroom?
No, sir.
I've never heard that argument made, and I don't remember ever reading any cases where they said that was improper.
Well, I haven't read any cases on it, but I've experienced it a number of times, and when the court has found that to be the case, they'd make inquiry and give some instruction to the spectator.
What kind of an instruction would you propose that the trial judge give in a case like that?
Well, if I had the honor of sitting in that seat, I would not allow it to happen because of the common sense to show that a husband that's going to sit there and watch a trial for 3 or 4 days is going to talk to his wife, and there may be opinions exchanged. And I've seen where the court has excluded that person from sitting in the audience. Of course, this court was very benevolent and said, I'm going to allow anyone that wants to come in here and sit. It's a public place, and they're allowed to sit here.
You'd agree, though, that we review that on abuse of discretion?
Yes, sir.
Standard?
Well, abuse of discretion. And the line of being adversarial, I did move for mistrial on it. Then the next occurrence was when we put our treating chiropractic physician on the stand, and that chiropractor was asked by me to give an opinion based upon reasonable medical probability as to whether or not the plaintiff sustained a permanent injury. To which
You've got 5 minutes left, counsel.
All right, thank you. 5 minutes on, before the rebuttal? Okay, thank you. At any rate, defense counsel objected to that, saying I had to ask him chiropractic probability, because he's a chiropractor. And I knew that not to be the law, but I went ahead and asked the question the way the court instructed me to do it. And I sent my paralegal quickly to the library to get a case on it, because I knew the law was that you could ask chiropractor reasonable medical probability, which is the case and was the case, and the court reviewed the case. We showed him, and then the court said you can, after some argument.
Did the court reverse that decision after you presented the court that case law and re-instructed the jury to disregard his earlier comment?
Yes, sir. It certainly did, but it said to the jury, gave a curative instruction, but it said the chiropractor can only testify as to the spine, which is, I didn't object to that because the court had already told me don't say anything else, okay? So, at any rate, the court said you can either amend the jury instructions to show chiropractic probability, or I'll give a curative instruction, or you can stand moot. I stood moot. And the court gave a curative instruction, which in my mind was not adequate. And then, just to hurry along, I want to get this in. I know I only have about 2 minutes left, but when I was doing my closing argument in this case, the court interrupted me and said, wait a minute. I'm 5 minutes into my argument. He says, wait a minute. The defense has evidence to offer in this case, which I've discussed with him. And, the defense had already closed and rested their case.
Well, counsel, didn't the trial judge then give you an opportunity to start all over again and give you the same amount of time he had allocated before? So in reality, you got 2 bites at the apple there. You got to make your first part of your argument twice.
Actually, I got 3 bites.
Okay, 3 bites.
But
and the jury still came in with a verdict against your client.
That's exactly right. And what I'm saying is, as an adversarial approach to the case was that he's lining up with the defendant in the case to be assured that the defendant got all his evidence in, even though the defense had rested. Thank you very much.
Thank you, sir.
May it please the court, my name is Rhonda Bogus, and I represent the appellee, Mr. French, in this matter. Mr. French was the defendant in this action, which did come back with a jury verdict of no negligence, which was the legal cause of damage to the plaintiff. I'll present my arguments in the order in which it was addressed by the appellant. On the first issue, as to the admission of the deposition of Mr. Bubness, the court has before it, it's in the supplemental record 1 through 4, the affidavit of the process server. At the time of the trial, the only objection made to the admission of the deposition was that it did not comply with the 100-mile rule. There was no other argument that this evidence would be insufficient. And as Judge Griffin pointed out, it is the Crow decision where the judge reversed. The trial judge there had refused to allow deposition in after there had been sworn testimony by the attorney and a deputy that the witness was not available and could not be subpoenaed, and the court said that it was basically reversible error for that deposition to not be admitted. So in this case, what we have is sworn affidavit from the process server that after diligent search and inquiry, this is not I went out to one address and they weren't there, that they couldn't find him. And in fact, the affidavit says that the owner of the location where he had been located at his deposition says his whereabouts are unknown. So there was definitely inquiry made. And there was no objection made at the trial to this being insufficient. The case law, which we've cited in our brief, makes it clear that, again, this is an abuse of discretion standard. They've certainly not met that. Even if you look at it, the case law is also clear that if you have any kind of reasonable grounds and evidence to allow the deposition in, you would. In fact, I would submit that it would have been error for the deposition not to be admitted. On the second issue relating to the jury, to the spectator being the husband of a juror, in fact, the husband informed the court that he was a law enforcement officer and he, under no circumstances, would discuss the matter with the juror and left. There is no rule that the sequestration rule does not apply to public members who have the right to see trials, and in any event, there's certainly no showing that there was any type of a prejudice that occurred in this case. As to the testimony of the chiropractor, it is correct that initially the trial judge did require the testimony to be in reasonable degree of chiropractic probability. After the trial counsel for the plaintiff pointed out that there was a case that said that was an error, the judge gave a very detailed curative instruction, not please disregard my previous ruling, I'm going to allow him to testify. He said I need to retract the previous ruling. That was a mistake on my part. This witness is qualified to give opinion testimony as to the spine within a reasonable degree of medical probability. Please disregard my previous ruling about chiropractic or that it was chiropractic probability. He is qualified under the laws of Florida to give testimony as to a reasonable medical probability, at least on issues of the spine. And that's on 364 and 365. So it was a very strong curative instruction, certainly would not be prejudicial to the plaintiff whose position actually prevailed and the trial judge had to admit he was wrong. Then after that, not only was there a curative instruction, but the plaintiff was allowed to basically re-question the chiropractor in terms of reasonable degree of medical probability, and he gave an 8% impairment rating. Thereafter, even further occurred when on cross-examination or by the defense counsel, they pointed out, the chiropractor testified that whether you say reasonable degree of medical probability or chiropractic probability, it didn't affect his opinion. His opinion is the same. So there's no showing here. There was a timely objection, but there was a curative instruction. There was no motion for mistrial made on that issue, and even event that it's totally been cured, and it certainly does not rise to the level of fundamental error. If anything, because of the fact that everyone was trying to cure this error, and there was a testimony both on direct and recross and the instruction by the judge, it only gave additional emphasis to that testimony, which was in the plaintiff's favor. On the interruption on the closing, again, the first issue that was cited in their brief was that somehow the trial judge took an adversarial role. And in fact, the only thing they cite in the brief itself is this interruption during closing, and basically argue that somehow by allowing the defense to put in these exhibits during closing that this was a favor to the defense and was somehow favoring the defense. But prior to that, there was during the conference, after the close of the defendant's evidence, and when they were having the discussions about housekeeping matters, the defense counsel had stated that he had neglected to move into evidence exhibits that he had used. The trial court agreed, I'll let you do that before we start closing. There was no objection made by plaintiff's counsel to that procedure being followed. So that was what was supposed to happen. In fact, it didn't occur, and therefore the judge interrupted and basically said, oh, I made a mistake, I was supposed to allow them to. And as Your Honor pointed out, he was allowed to start his closing again. There's no favoritism. The judge had agreed to do that. Plaintiff's counsel had agreed to allow him to move those documents into evidence. The only reason they had not been moved into evidence previously is that they needed to come in the case in chief instead of in cross. It certainly does not rise to the level of fundamental error. And that's really what I'd like to end with, in that the majority of the arguments that are being brought by plaintiffs have really not been preserved, particularly as to the trial judge. There was a motion for mistrial due to the prejudice, the perceived prejudice of the trial judge. That motion was made outside of the presence of the jury, and the trial judge did rebuke counsel for his attack on his personal integrity and on the attack of the court. But again, that occurred outside the presence of the jury, could not taint the jury. And in fact, and probably in recognition of that, that's not even cited by the appellant specifically in their brief. The only thing that is cited by the appellants in their brief is the interruption in closing, which was not prejudicial, was not adversarial, and to which there was no contemporaneous objection, which would be required, short of fundamental error. And then they also cite, and on page 6 and 7 of the brief, about 6 different evidentiary type rulings. Certainly, I think it's beyond debate that a trial judge's adverse rulings do not indicate that the trial judge is prejudiced or impartial towards the party as a matter of law. That's the trial judge's role, and that is his duty to comply and to apply the rule of evidence. In fact, the majority of the rulings in which the plaintiffs complain on page 6 and 7 are those that relate to permanency and damage. Even if there was an error, completely harmless. There was no determination by the jury. They didn't get that far because, frankly, they didn't believe this accident occurred. The last 2 were the spectator, which we've already talked about, and then there was also a discussion in the brief about rebuttal testimony. That's also something that trial judges have discretion in whether to allow. And it's very clear when you read the record that the only rebuttal testimony that the plaintiff wished to bring in was who was wearing purple, because, in fact, the witness testified that it was the plaintiff that was wearing purple as opposed to the witness. And there was no need for rebuttal testimony on that because the plaintiff's attorney had made sure that the witness, in fact, wore purple to the trial. And also some rebuttal testimony about where this Mr. Bubness was, but that testimony was also in the case in chief, and in fact there was even a further stipulation as to where Mr. Bubness was to make that clear. So in any event, that's an abuse of discretion, and that hasn't been shown, but I would also submit to you that was the appropriate ruling. So as to the 3 issues they've mentioned, one was the prejudicial conduct of the trial judge. Don't think it occurred. If it did, it wasn't preserved. Even if there were comments that someone might criticize, they certainly do not rise to the level of fundamental error so as to deprive the plaintiff of their day in court. The deposition was properly admitted, and while the trial judge didn't initially make an improper ruling as to the chiropractor's testimony, that was completely cured, and in fact, because of the nature of the cure and the subsequent testimony which came in, that was ultimately the plaintiff's favor, and certainly does not justify a new trial. Unless your honors have any additional questions, I'll stand on the brief and request that you affirm the judgment.
Thank you, counsel.